we are Court Watch Nola, so we've been court watching in New Orleans since 2007, and we are partnering with Southern University Law Center to launch a court watching program in Baton Rouge. We are starting with Call Out, which is the first appearance for the 19th Judicial District Courthouse. And that's what we're going to focus on today is that that particular hearing. So let's see here. Next slide.
Is this better, Jesse?
Yeah, there you go. Yeah, you're a lot better. Do you want to swap out your slide deck? Yeah, so like I noted, we've been court watching for a long time in New Orleans. We're starting with Call Out in Baton Rouge, and this awesome partnership with SULC Law Center. I guess that's redundant, just SULC. But we just in general about what we do when we go into court. Who are we watching? Who are we watching when we walk in the building? The first three are kind of what most people think of, right? When you think of like going into court and observing what's happening. The judge is the person who probably gets the most attention. Then the district attorney's office or the prosecution and the defense attorneys. Those are private defense attorneys and the public defender's office. We call these the three pillars of the court. So obviously we are paying close attention to what those folks are doing. We're also looking at the sheriff's office. The sheriff's office is responsible for everyone's safety. So that is obviously the safety and the care of the arrested persons who are incarcerated and are making case appearances in court. Remember that all of those people are innocent until proven guilty. And so they are appearing as innocent people. Their care or their safety is in the hands of the sheriff's department. And there are a lot of really valid concerns about how safe those people are. And so we're paying close attention to that. But also the safety of everybody who walks through the door, right? When you'll see when we go through in our in-court training, they have X-ray machines and metal detectors, right? Because there are some people who are really unhappy with the outcomes from that building, and they might walk in and want to do people harm. And so the sheriff's office is responsible for keeping everyone in there safe. Police department, obviously, they're going to be the arresting officers in most of the cases that we see. Although I will say I recently found out there are almost 40 different jurisdictions that can be the arresting jurisdiction for cases that we see in Call Out. So it's there's a big cast of characters there. And then also the clerks. Those courtrooms, they run on paperwork and sometimes literal paper files that get passed around. I know in New Orleans, our clerks didn't get email addresses until about 2 years ago, believe it or not. So Baton Rouge is doing a little bit better than that. But yeah, like the logistics and the paperwork involved, nothing happens in that building if the clerks aren't on the ball. So we're looking at everybody there. What are some of the things we've accomplished? This is one of the things I think is the real strength of this program that we do, because we have things that we've won for the public, specifically in New Orleans. So material witness warrants. Our former district attorney was arresting people in order to force them to testify in their own cases. In some cases, these were survivors of domestic abuse and sexual assault. He was using fake subpoenas. We reported on this practice and then helped get laws passed that put a lot of guardrails on it. We wanted it banned altogether. We didn't get quite that far, but at least there's a bunch of red tape now. They weren't using, scientific confirmation tests at the drug lab. State Supreme Court stepped in and made rules that every drug lab has to use the same machine and the same test. And that came after our reports. We've helped get interpreters in court. We've helped expose judicial corruption. The big thing that all of these have in common is that they all came out of data that was collected by our court watchers. It was like a shared accomplishment. Some of these cases, like we got tips from outside, we got whistleblower reports, but we were able to go back and corroborate things and verify things based on court watcher collected data. And so this program has something tangible you can do to have an impact. And I think that if you participate with us in doing this, in a couple of years, you'll be able to look back and say, there is an accomplishment, there is something that happened that made the system better, and I was able to contribute a piece to that. We have so many things where, we tell people like, hey, this system is broken and it's really hurting people. And then they say, okay, great, what can I do? And we're like, I don't know. I mean, I guess you could vote. Like voting should help. But this is something, voting's important, don't get me wrong, but this is something you can actually roll up your sleeves and you can get involved. And I think that's really cool. This is one of those, like we go, Darrin, you can go ahead and click onto the next two because we don't need to do the mystery part here. This is something that in, our longer trainings where it's not over lunchtime and we're trying to get people back to work, we will go into like much more detail on what this means. But essentially, we have a lot of really important values, but objectivity, I think, is the one that's most important to the work that we do and the one that's most important to talk about now. By objectivity, we mean we don't go in with a bias before we start, and we emphasize using data to back up our arguments, and we collect data to show that. I'm an English professor. Bias isn't necessarily bad. Bias is something that you have to account for. When you're reading something, you have to analyze the bias and ask, how does this change the outcome? How does it change the information that the person is presenting to me? But just because something comes from a source that has bias doesn't mean that that information is worthless. It just means that you need to discuss the bias and know how it affects things. There are court watching programs that have a very specific stated bias, and they do really good work. Just because they go in and they say, we want to eliminate cash bail, and that's what we're court watching for, that doesn't mean that they're not doing good work. It just is a different approach. We want to go in and say like, hey, we want to collect the data and we want to look at what the data tells us and then make recommendations based on that. We don't want to go in and say, hey, we think that this thing is happening. And so we're going to go collect data that confirms that this thing is happening and then report on it. We think it makes a stronger argument if we collect the data, we look at what's there and then make recommendations that derive from that. Using the data to back up our arguments is important because, it makes things less subjective. It makes things less, less up for interpretation. If we went out and we said, hey, we think this judge is really unfair and is being mean to everyone, then somebody could argue with us. They could say, like, what do you mean by unfair? How are you judging fairness? But if we go in and we say, hey, we showed that last year this judge started court late 47 times, we think that shows a disrespect for the public, and we think that's a big issue. Well, you can't really argue with that because we have the receipts. We have the observations that show that section started late 47 times. So it cuts off, a lot of that room for interpretation and makes things a little neater. So that's why we put such a big emphasis on objectivity. I wish we could explore this more because it's a really important thing. But hopefully we get an opportunity in the future to go deeper here. Conflict of interest. So this is really important because it helps protect the integrity of the data that we collect and the points that we can make. The big picture is that if you have a conflict of interest, it just means we need to be careful about where we send you. It doesn't mean that you can't participate at all. It's really like if you have a personal or professional relationship with the judge, we shouldn't send you to observe that judge. You can go to see another judge's court and you'll be fine. But just that one judge, we shouldn't send you to that courtroom. So just let me know if you think you have a potential conflict of interest so we can be strategic about where we send you and make sure that the data that we collect and the points that we make are just beyond anybody's ability to question. They're beyond reproach. Courtroom conduct. So in general, we need to be a little bit better than the standard that everyone else is held to when we show up in court. Because of the nature of the work that we're doing, we are pushing back on people. We are trying to hold people accountable. We're fighting for transparency and fairness. And sometimes people don't appreciate that. And sometimes they have, some people in the past have found ways that they can push back on it. We recently had a situation where, we had a court watcher that made a mistake and had a phone go off in court because she didn't turn her phone off. And because of that, none of our court watchers can go into court anymore with phones in New Orleans. And, we disagreed the assessment. There were some accusations that maybe the person was trying to record the judge and put it on Facebook Live. And, it was just a little old lady who didn't know how to turn the ringer off. But, we have to be a little bit better, because if we give people an easy avenue to throw our court watcher out of court or make it harder for us to come and observe court, then it impedes our ability to hold people accountable like that. So dress code, is a thing that is a contentious topic. I think that these courts are buildings and offices that serve the public, and the public should be able to come in absolutely whatever they want, right? But the courts do have dress codes. They do have standards that they hold people to. I like to call this business casual is what I'm going to recommend to you. We've talked to different courts. Most of the time they say, like, we want you to wear dress pants, a collared shirt, and dress shoes. And if you can do that, that's great. That's absolutely great. If you can do that, please do so. But that's not within everybody's ability to do. And I don't think it's fair that you should have to have dress pants and dress shoes and a collared shirt. So if you, have to go in t-shirt and jeans, that's okay. Just make sure that it's something that is not going to be a distraction. If you're wearing jeans, just make sure they're not like full of rips and holes, right? If you're wearing a t-shirt, make sure it doesn't have anything that somebody could construe as offensive, even if it's not. I think that there is a minimum standard that we can uphold. So like no shorts, no tank tops, no sandals, and then no hats. Judges hate hats so much. But in general, again, I reject the notion and the respectability politics of dress codes, but we have to be a little bit better so we don't give anybody an easy way to throw us out of court. And that's sort of where we're at. Punctuality is, along the same lines. Like, a lot of people take that as a signifier of respect, whether or not it actually connotes a lack of respect. People will hold us to that standard. So, we want to be there to record the start of court. So punctuality is important for that. But also, people take it as a sign of respect. In general, we are observers, not participants. So, don't talk to the court unless the court talks to you. Some of the judges will like to hold conversations with you, and they'll ask you how you're doing, and they'll ask you if you understood what just happened, and they'll ask you, if you need anything, and that's great. Please engage if they engage, but don't initiate that. Just be an observer. Eating and drinking in the courtroom, this is one of those things that's like maybe some of the judges would be okay with it. Maybe some of the judges would take offense to it. We just don't want to risk it. So if you need to step out in the hallway and have a bite of a granola bar because your blood sugar's low, or you're just parched and you need a sip of water, or you need to go to the bathroom, take care of yourself. Do what you need to do. Protect your body, because if you're going to pass out from hunger, you're not going to collect good data. You're not going to have a good time in there. So we want you to be comfortable. We want you to be, we want you to feel like you're okay, and you're feeling like yourself. And so if you need to take care of yourself, it's okay to step out of court. You'll see people coming in and out of that room, and it's fine. It's not a distraction. So step out in the hallway, do what you need to do, and then come back when you're ready. And also, that includes if you're having a hard time with the proceedings that you're seeing. If you are having a PTSD reaction, you are not going to collect good data. And you know what? You're not likely to come back. You're likely to be a one and done. If you sit there and subject yourself to something that is causing you emotional or mental trauma, then if you need to step away, then step away and come back when you're ready. I want you to protect yourself. And so that is my priority here. It's more important than the data. And then no pictures or recordings. That's just a law. They have signs up, but you could get in serious trouble. You could get fined. You could theoretically get arrested. Please make sure that you don't take pictures or recordings. Expectations for court watchers. So I've been observing call out for a while. In my experience, they're running about 2 hours. They start at 1 o'clock Monday through Friday. Some of the judges aren't running on Friday, but some of them are. So in general, we're looking at around that window. Basically you will set your availability and tell me what days you're available to observe court. And then I will assign people to go based on the availability that you set for me. So if you tell me that I'm not available on Wednesdays, I'm not going to send you on a Wednesday because you told me you're not available. You need to keep that updated for me. So if you have permanent changes to your schedule, you'll have an upload form that you can go just put in a new form. If you have a 1 week change, you're like, I'm normally available on Mondays, but I'm just not this week, you can just send me an email and that's fine. But I do need you to keep that updated before I make the schedule. I will send the schedule out. And whatever email you give me, you need to check to make sure that you are or you aren't on the calendar for the next week, so you know what day you're assigned. And then after you do your observation, you need to upload your data within 48 hours. So you'll have a link that you go to upload your data. The paper form you use is just a collection tool. What really matters is when you put it into our statistical database. And then that we're asking you to do within 48 hours. It's better if you do it right after the observation, but we know that's not in the cards for everyone. So 48 hours is what we're asking. And then if you were doing this for class credit and you need to track your hours, you will need to track those. We have a bunch of, we've worked with over 80 schools over the last few years. They all have different requirements. I can't keep track of all of them. So, we will work with you best as we can to support you in that. You will have hours recorded for when your observation stopped and ended, and that will be on your data sheet when you upload. But if you need a form that says this is how many hours I've done, you're going to need to keep track of that so we can help you and get that stuff certified. So. And then that's it for me. I'm going to hand it over to Darrin. Darrin is going to do the path of a case here. And then I'll jump in at the end and we'll talk about the next step, bringing you to the in-court training and then getting you activated and ready to go.
Hello, everybody. My name is Darrin Browder. I am a product of Southern University Law Center, alumni from 2001. I have worked in and out of criminal courts since I graduated from law school, and criminal law has always been my interest. And so this running of Court Watch for me is almost like a dream job. And so this is why I do what I do. The reason why I do what I do, because it could have been me. It could have been me wrongfully accused for a crime that I didn't do and spending 20 years in jail before they find out that I'm innocent and then release me. So this is why I do what I do, because it could have been me. All right, call out in East Baton Rouge Parish or the 19th JDC. They only hear state felony charges, what we'll be watching. It starts at 1 p.m. And it's Monday through Friday. As Jesse said, some Fridays they do not have a call out. They may have a commissioner appear to do the call out for them. These are the sections of court. Section 1 is Judge Crafassi. Section 2 is Judge Ray. Section 3 is Judge Myers. Judge Johnson is Judge Johnson Rose is Section 4. Section 5 is Judge Smith. 6 is Judge Jordan. 7 is ad hoc. I believe that election is coming up soon. And Judge Foxworth Roberts is Section 8. So some of my law students will know that a felony versus a misdemeanor, the only actual difference is the hard labor in the sentencing side of the law. Hard labor is the term used for all felony crimes, meaning that that crime, if convicted, is punishable by hard labor. A misdemeanor is just a general reading of the law, and you won't find hard labor anywhere in there. It does not mean anything other than it is less serious than a felony, which usually comes out in the sentencing portion, meaning the time that someone will have to do prior to being released from jail. Now, the U.S. Constitution says in the 13th Amendment, it says neither slavery nor involuntary servitude, except as punishment for a crime, wherefore the party shall be duly convicted, shall exist within the United States or any place subject to their jurisdiction, meaning that slavery was moved from general servitude, where you could be picked up and sent to a plantation to work. No longer that is in effect now. If you're convicted of a crime, this is used as punishment. So this slavery aspect in America is still in existence. It just has moved toward the prison industrial complex. And this is where you will have people working in maybe say a farm that is run by a prison, and they pay you pennies on a dollar, where the actual prison will make a profit. That's when you have these for-profit prisons around the country. That's the slavery annotation of the 13th Amendment that has been moved to the crime side. All right, so what we talk about is the path of the case. In call out basically means that you have been recently arrested. And the law in Louisiana says you within 24 to 48 hours, you must go before a judge to have 3 things taken care of. Well, actually, technically 2, but the third thing is something that we push forward for. But we'll talk about that in the next slide. And then in the second appearance is usually in Orleans Parish. What they do is to protect that 701 right. The 701 right means that the DA's office has a timeline that they have to file a bill of indictment or bill of information in this case, in order to move it to the next phase, which is the trial side. And so they want to make sure that the 30 days, because there's 30 days for a misdemeanor, although we don't have a misdemeanor in call out, it's 30 days if someone gets arrested for a misdemeanor, 60 days or 45 days for a felony, and then 60 days is for a capital offense if this person is arrested. If they're out of jail, it's 150 days that they have to file this in. On the trial side, which we won't be watching, there's an arraignment, discovery, motions, all that we'll talk about once we move to that and start watching the trial side. But right now, all you got to worry about is that call out, that first appearance. All right, so in this hypothetical, the only way for me to get you to understand this is if you can visualize me, Darrin Browder, committing an actual crime. And visualize the fact that, there is an issue where we have a lot of guns in the neighborhood, right? Everybody's carrying a gun nowadays. So just to say that Darrin Browder pulls a weapon, allegedly pulls a weapon, a gun, points it at someone and pulls that trigger, but the gun did not fire, okay? BRPD will arrive on the scene. They take me into custody, they interview witnesses, and then they take me to booking, okay? That's the process. Once I'm booked, Then I'm brought over to see a judge within 24 to 48 hours. Now, on the weekend, it does not count. On a weekend, you will not have to be brought before a judge to have a bond set or probable cause determined. The weekends and holidays do not count. All right, so I will be booked for aggravated assault. So for my law students in there, the aggravated assault is the pulling of that weapon and pointing it at someone. That is the aggravated part. The gun is the aggravated part. The assault is the apprehension of that battery. Okay. All right. And so just thinking about that, having someone pull a gun on you and pointing it at you is a crime. That's aggravated assault. The pulling of the trigger is an attempted murder. The fact that that gun did not go off does not mean my intent was for not to shoot you, or allegedly not to shoot you. Okay. The pulling of that trigger had an intent for that gun to fire. Okay. And so these two charges that I will be booked for will be aggravated assault and attempted murder. Hopefully everybody understands that. All right. Both of these are felonies. Okay. And have an extensive amount of time, which we won't get into because all we're looking at is the actual charge correctly right now. All right, so first appearance. When you go before this judge, the one thing that Watch Nola has strove for and worked hard for all our time, all 17 years, but at least the 5 years that I've been here, was to get appointment of counsel immediately. Okay. We want appointment of counsel because you have that right. On the Fifth Amendment side, upon that arrest, you have that right to remain silent. And on the Sixth Amendment side, you actually have that exact same right in court. But if a counsel is not appointed, then how are you to communicate pros and cons to the court? And so over the years, we've worked for this and we fought for this in court to make sure that everybody, no matter how much money they make, whether they had a lawyer there or not, that a lawyer is there to represent them and to protect their rights in court. And so appointment of counsel is something that we will strive for in New Orleans Parish. We're going to strive for in Baton Rouge. No matter who you are, no matter how much money you make, you need appointment of counsel at that particular case, at that particular point. And so Criminal Code 230 says appointment of counsel is something that the court can do and should do. Now, and the second thing is required of the court is to determine probable cause. Now, we'll talk about the two ways probable cause it will show itself in call out, but the main thing is there must be a determination of probable cause at this appearance, because probable cause, basically, we'll talk about the next slide, that you can hold somebody over for trial. It's a very low standard. It's one of the lowest standards in law itself, but it's still required in order to move this process forward. And then review that bond and notify of charges within 48 hours. So reviewing that bond. So that bond is basically going to be what is going to secure your presence in court. That means that there's going to could be a financial bond set, or there could be a release on your own recognizance. We'll talk about that later. But those are things that are important, that you know of these charges that could be potentially come against you, and you know that there's a bond set that will enable you to be free while defending these charges. Any questions so far? Am I going too fast? All right. Appointment of counsel. Okay. Now, in Orleans Parish, as an EBR, there are a group of lawyers called public defenders. The public defenders are state defenders, right? They're paid for by the state, although there is a fee at the end that is required to be paid back to the state by the person who's being defended or the defendant. And so who can get a public defender? One of the requirements for a public defender is your indigency, meaning that you do not make a certain amount of money or above a certain amount of money, or you do not have means to pay for a private attorney. How does the court determine who is indigent? Mainly, they ask the question of, are you working? If you're working, how much money do you make? If you make below $15 an hour and you have dependents, usually they can deem you indigent, or you'll have social, what is it? We talked about it yesterday. Social security where you're getting paid because you have disability, right? If you have disability, that automatically makes you indigent. And so that means you're required, the court is required to protect your right and have a public defender appointed. And so what happens if you don't get a public defender? Well, if you don't get a public defender, it is up to you to are required to bring a lawyer to court at your next proceeding. In Baton Rouge, it's not a real concept. They'll just tell you you don't have a public defender, or they won't even say anything, but that person will not have counsel. They will have to find their own counsel. But that doesn't mean you cannot get counsel. You could always have a loved one or family member to talk to the public defender's office or call counsel, and hopefully get someone there for you, protect your rights. So we talked about probable cause, and that's something that the court is required to determine upon them in that first 48 hours, right? And so when we talk about this, I want someone to read this sentence 3 times, and whoever does it, please read it 3 times. Need a volunteer. Anybody?
Now, what do you mean? The facts that would lead a reasonable person to believe, I can't see the things that believe the defendant has committed a crime.
Yes.
Facts that would lead a reasonable person to believe the defendant has committed a crime.
Last time.
Facts that would lead a reasonable person to believe the defendant has committed a crime.
Right. And so that is a definition of probable cause. Okay. So what are the facts? In my instance, the facts are that Darrin Browder allegedly pulled a gun, pointed it at someone, and pulled the trigger. Those are the alleged facts. Those facts will be transmitted in 2 different ways. We'll talk about that in the next slide, but those facts will be transmitted to the court in 2 different ways. One way is a gist, one way is a warrant. All right. And so when you talk about the facts that are given to the court, well, who is that reasonable person? Well, that reasonable person is a judge or a commissioner that sits and listens to these facts to determine probable cause, right? Whether or not those facts led them to believe that me, Darrin Browder, committed a crime. But again, this is the very lowest standard in law. Okay. So what number would quantify probable cause? I'm gonna give you an example. In court, Jesse and I once witnessed a judge who got some facts that 2 police officers witnessed a drug deal. The drug deal happened when 2 people got together, got their money together, walked over to another person, handed them money, and allegedly this other person handed them drugs. In this case, everybody was arrested, including the drug dealer and including the drug purchasers. But in the end, in that arrest, when they were searched, no drugs were found. I'll say that again. In the end, when these guys were arrested, no drugs were found. However, the court, that reasonable person, still found probable cause that someone committed an actual crime. It's illegal to purchase drugs, it's illegal to sell drugs. And in this case, probable cause was found that someone purchased drugs and someone sold drugs. That's how low it is. I wouldn't have believed it unless I saw it, okay? And so earlier we talked about a warrant, right? Yeah, make sure I didn't miss something. Earlier we talked about a warrant versus APC, right? So we're going to talk about APC. In Orleans Parish, we call it, APC is called a gist, right? But an APC is an affidavit of probable cause. That's what the police give to the reasonable person, which is the court. Now, a warrant is, on another hand, is a whole nother animal. That warrant basically is basically walking probable cause, that anywhere in this country, you can be arrested by any policing agency in this country. So if I committed a crime in Baton Rouge and I'm in California, LAPD or the Los Angeles Sheriff's Department or wherever I am can arrest me, detain me, and send me back to Louisiana. Okay, anyone. And so a warrant, though, is walking probable cause, where it automatically comes in there with probable cause because a warrant is signed by a judge. Although those facts in that warrant is written out by a police officer, once it's signed by a judge, it is walking probable cause, and a judge cannot say, I find no probable cause on this warrant. There has to be a hearing. Now, an APC or affidavit of probable cause is not walking probable cause. It's just the facts that then have to be delivered to the reasonable person who is the judge, who then determines whether or not that gist or that APC or those facts warrants probable cause. And they can say, no, I find no probable cause based on those facts. And so that's the difference between a warrant versus a gist or a APC. All right. So it means probable cause to do what? Probable cause to hold that person until trial. Okay. That means that now, once they find probable cause, you have to now pay a bond or a security to get out of jail to defend yourself. Otherwise, you will stay in jail. All right. So again, we're going to cover this. Judges cannot find no PC on a warrant. Okay. No PC basically means no probable cause. That means they cannot hold you for trial if a judge finds no probable cause. Probable cause or PC on a warrant can be only challenged at a preliminary hearing, which can be held only at a later time. Judge can find no PC on an APC though, because remember, APC is only facts that have not been established as probable cause because there's a judge has not signed it yet. But when a judge says, I find probable cause on this APC, that technically attaches to the APC and gives it probable cause. All right. The judge can also find no PC on an APC, or no probable cause on an APC, but find a lesser charge that has probable cause. Give you an example. Say somebody has possession with intent to distribute cocaine. All right, that means you're dealing. You have a ton of drugs that you're selling to other people. Okay. However, when you're arrested, you're only arrested with a slight bit, say a gram. Okay. And in that instance, there's no scale, there's nothing else, there's no large amounts of money, there's just the drug. In that instance, the judge can say, well, I find no probable cause for possession with intent to distribute, but I find probable cause for simple possession of cocaine. All right. That's what they can do. And you will often see that in these cases in EBR. And then what happens if there's no probable cause found? That person is released. No charge at this particular point, as well as no bond obligation. And so when there's no probable cause, that does not mean that that case could go away, because the DA can later on come back and file a warrant and have you rearrested, and the process starts all over again. All right. All right. So once probable cause is found, now they have to determine what that bond or bail should be. Bail or bond means the same exact thing. All right. It's a security given by a person to assure the defendant's appearance before the proper court whenever required. And so that basically means, you ever been rented an apartment, you're giving up security to that apartment complex that you will get in the end when you move out. That's exactly what bail is supposed to be. It's not supposed to be something that burdens you. It's not supposed to be something that hammers you over your head. It's not supposed to be something that is a problem for you to get, right? It's supposed to give security so that you can leave and go back to your life and defend this crime or this charge from your home, because again, you're deemed innocent until proven guilty. The perfect example of this is our former president, Donald Trump. Donald Trump is considered innocent until proven guilty. No matter how many times we see him say things on TV that could be criminal, he's still innocent until a DA proves him guilty. Okay, so bail is not supposed to be punitive. It's not supposed to be damaging. It's not supposed to be harmful. It's supposed to be something that, hey, hold this for me till this trial is over. And no matter what the outcome is, if I'm found guilty in my case, okay, I'm getting that money back. Minus a certain percentage of it, I'm getting a majority of my money back. All right. So what are the obligations of the court when determining bail and bond? Now, these factors are set up in Criminal Code of Procedure 316. This is not something that Darrin Browder and Jesse got together and said, hey, you know, it'd be cool if we can force the court to do this. No, the state legislature is forcing the court to do this. But why court watch is important is because no one knows if the court is actually setting bond required to this actual law that's in place for them to do. So I'm gonna go through this right quick. So factors for setting bond. One thing is going to be the seriousness of the offense charge. And so in my case, an actual attempted murder is pretty serious. It's not for play. It's pretty serious. So that's going to raise my bond considerably. The danger to the victim or the community. If there's any death threats that I put out there on Facebook or Instagram, that will raise my bond and the danger to the community or the victim. Weight of the evidence, right? So say I get arrested in possession of the alleged gun that I pointed at someone. That's weighted evidence. That means I had a weapon. It's more likely than not that I pointed it at somebody. The defendant was out on an open case. Say I had an open case, another attempted murder charge. That would raise my bond. These are all factors the court should be considering. And in my idea, should be putting on the record to protect themselves when they do set an astronomical amount of bond on people, not just say, oh, your bond is $55 million or $30,000 or $10. They need these factors to support why they set this bond. All right, so previous criminal record. If this person has an extensive criminal record, and it does not mean it has to be a violent, it could be drug use, it could be anything at this particular point, and it doesn't have to be a conviction. It could be an arrest. At this stage, it can be an arrest. All right, so absence or presence of controlled dangerous substance. So I have drugs on me. They will consider that. If I have drugs in my system, that can be considered as well. And so these are things that the court can say, I can raise your bond or I can lower your bond. The ability of the defendant to give bail. This is something that has moved me more than anything. So this basically means that the court is required to ask, how much can the defendant pay? I'll say it again. How much can the defendant pay? It's not something that Darrin made up. This is in CCP 316. You can look this up, Criminal Code of Procedure. This is also the same in Florida. It's also the same in Missouri. They have to require, the court is required to ask, how much can a defendant pay? And I've only seen it asked one time. The street value of illegal drugs involved in a charge. So if you're selling these drugs, right, how much drugs were you trying to sell? And what was the street value? Can be considered or should be considered in factors of setting bail. And then the defendant's volunteering for pretrial drug testing. And so in issues where you are arrested for drug use, okay, some of these things can be required. And I've seen this a lot in EBR. When they set these bonds, they ask them to volunteer, or they don't volunteer. They tell them mandatorily they have to go through pretrial drug testing and some sort of training. And then any other circumstance affecting the probability of the arrestee's appearance. Okay, and so these are the things that the court is required to ask or consider when setting bond, and should be put on the record to protect when setting these bonds. But I rarely see them in EBR. All right, and so the one thing that I see that would benefit the court more would be mitigating and aggravating factors, and I haven't seen that much in EBR, where you would have a state attorney or a ADA or the state or the prosecutor attorney or the DA's office offering aggravating factors that would raise somebody's bond. One would be what is the criminal record? The person that has the evidence of the person's criminal record is the DA's office. They have NCIC, which is the National Criminal, I forgot what the I is, but it is a website that has all the arrests of anybody in the country. So if you've ever been arrested, they can go to this website or this computer and pull up your entire criminal history forever. All right. And they can tell you they can tell the court how many times this person's been arrested, whether he's been convicted or not, whether he's had a sentence or not, whether he's on probation. All this comes from your criminal record. They can also go look in and say how many times this person failed to appear for court. right? They can talk about this person's from Mississippi and has no ties to the community, so that bond should be higher in order that he can come back and get that money. And then if this is a crime of violence, that also should raise their bond, or that's an aggravating factor that the DA can often use to raise the bond. But because they only ask the DA's office about these aggravating factors, they rarely ask any mitigating factors, which would be beneficial to the court to figure out what is happening in this situation, like lack of criminal record, ties to the community, employment, family support. Some of these things should be offered by the defense attorney when appointed, and that could mitigate and lessen, because remember, this person is innocent. They're not guilty. They could be video of me shooting someone. I'm innocent until proven guilty, okay? And so all these mitigating factors should be added to the record in order for this judge to have as much information as he can for setting that bond. All right, so what will my bond or bail be? Let's just say for the attempted murder, it's $500,000. All right, straight up, $500,000. For the aggravated assault, it's $250,000 for a total of $750,000. Now, how could I pay this bond, or how is bond paid? There's a couple ways. One way is I walk up to the court with a big old duffel bag of $750,000 or hundreds, and I hand it to the court. Or I could put up property or whatever I can to match that $750,000. If I give $750,000 to the court at the end of my trial, whether I'm convicted or not, I will receive $750,000 back minus a small percentage of that. That's less than 10%, maybe 5 or 6% will come back to me. All of it will come back to me. All right. The other way is to go to a commercial bondsman and required to pay like 12%. And so I would have to pay $90,000, okay, to a commercial bondsman to get out of jail. All right. Now, like I said, that will be returned to me. If I make all my appearances and I don't get thrown back in jail because I missed so many appearances. However, that 90 grand that goes to a bondsman, it's gone forever. I will never see that money again. Ever. And so what would make somebody want to come back? I've lost $90,000 that I could have used to actually pay for my attorney. Right? So there's no such thing as, I get that money back from a bondsman. The bondsman makes that 90 grand and moves on. Okay. And hopefully they wish that I can come back and make it all the appearances. If I don't, they can get off that bond before losing that 90 grand or losing $750,000. All right. So non-financial bonds means that it's zero. That means you don't have to give the court anything. You sign out or promise to come back, right? And so one of the ways that we're going to get released is an ROR, or release on your own recognizance. But if you have a crime of violence like the charge that I'm charged with, which is aggravated assault and attempted murder, I'm not eligible for an ROR bond. So that means I have to have a cash bond that is put on me. There's also a thing called a sign-out bond that the person who's close to you, like a father, a mother, a grandfather, they can come out, a husband or a wife can come and sign you out specifically, but they have to get that name to that person to the court. That court contacts them, they vet that person, and upon that vetting coming back as positive, they can sign you out, all right, or sign me out. But in most cases, I'm not eligible for a sign-out bond either because of my crime of violence. All right. So conditions of release. So a couple of things that the court will put on your on you if you're released. If you have a sign-out bond or if you have an RR, will be a drug test. All right. If you're charged with a drug offense, 9 times out of 10, you will have a drug test. It could be random. It could be weekly. If it's domestic violence and there's a stay-away order in place, you will be prohibited from having firearms. In my case, I can definitely swear that I will not have to have, I will be prohibited from having a firearm in my possession. In cases where there is a protective order or a stay away order, that firearm that I'm in possession of must be turned over to the sheriff's department. That is required by law. I could also be required to have an ankle monitor attached to my leg, and then upon my release, I would have 24 to 48 hours to return to court to show this judge that my ankle monitor is working and the company that I am with. There can also be a curfew that can be instituted for you to be in jail, usually with a protective order and an ankle monitor. There is a curfew. They will allow you to go to school and get a job, but that curfew will be enforced emphatically. Mental health or drug treatment, if there is a mental health issue, a lot of times if you're released, you'll be released to a mental health organization or a hospital or some sort of drug treatment plan that you can be signed out to. And an interlocking device will go on your car if you have a DWI, and then or forbidden to leave the jurisdiction, meaning that already once you're released, you cannot leave the jurisdiction without having to file some sort of paperwork saying a motion to leave jurisdiction, which the judge would then sign off on, and then have some sort of requirement of you checking in weekly with the court personnel to make sure that you're not missing any important court dates. All right, so what data do we collect? We collect name, defense attorney, whether or not you have a defense attorney, charges, whether arrested person was present, because that's very important. We don't want anything to happen or anything to be ruled on without the person knowing, because that's part of the process. You know exactly what's going on. That's why you have a lawyer appointed. Ethnicity, gender, income, housing, whether a probable cause is found, any risk questions. Risk questions are something that we're looking to get instituted, or is there a risk for releasing you? Mainly, did you have any failures to appear in the past? Are you on probation? These could be any risk questions. What factors were used or for setting that bond? Meaning that those 330, I think it is, article. What were the risk factors mentioned by the judge for releasing you or setting that bond? Access to guns. That question should be asked. Do you have access to guns? If I was just to ask that question to understand, to protect the community, that's what the court will do. Can they afford the bond, right? That should be a question that's asked because it's required by the law. The amount of bond set is what we collect, and then any other non-financial conditions to release, like ankle monitor, interlocking system, protective order, stay away order, those we collect when we hear listening for the judge to put these requirements on the person who's been recently arrested. All right, I'm not going to get into all this, but because we won't see a second or second appearance in EBR, but just give you a heads up, there is a thing called a Gwen's Law hearing. There can be an issue or a 313 hearing. 313 hearing is the same as a Gwen's Law hearing. It's only in domestic violence cases where there can be a hearing. So that means you will have no bond set until the next court appearance, where they will have a hearing that they will look at more evidence. They will even bring in witnesses, maybe the victim, maybe witnesses, to talk about this, how much bond this person should have because of this arrest, right? A preliminary hearing was something that they use to attack a warrant or probable cause, and there could also be a chance to have a hearing determined counsel date. That means that if you don't have a lawyer and you say you're looking to hire a lawyer, the court needs to know when you hire that lawyer. So they can give you 7 days to hire a lawyer. That lawyer will come in and sign on to the records as your attorney, and then be there to make sure he can defend you at every other proceeding. And then the 701 date is basically the date that the DA has to file a bill of indictment or a grand jury indictment, or bill of information or grand jury indictment before they have to let you go. All right. So 30 days is misdemeanor, 45 days is a felony, and 60 days is a felony, 90 days is for capital offense if you're held in jail. All right, and so we talked about bills of information and grand jury indictment. All right, so this is a recap. So first appearance happens within 24 to 48 hours. Weekends and holidays are not included in that 24 hours. So if you get arrested on a Friday night after call out, it's probably likely that you won't get to see a judge until Monday. Okay. We want to see appointment of counsel, determinant of indigency, and then probable cause. And we like to get appointment of counsel prior to the probable cause and a bond setting, because then they can speak on your behalf in a mitigating factor. But usually it happens after he's found probable cause and appoints counsel. And in that particular point, you're already, behind the 8 ball, because the bond could be a little bit higher than expected for you to get to put the bond out. Probable cause is determined. Affidavit of probable cause is issued to the court so that they can determine probable cause based on those facts. And then a warrant. A warrant is walking probable cause. A judge cannot invalidate a warrant unless there's a hearing. 51% is the low standard of determining probable cause. And then the charges do not disappear if you are released on a 701 hearing, or if the court does not find probable cause. Those charges do not disappear. They technically do disappear, but they can also be revisited by the DA at a later date. And then bail and bond. Bail or bond is something that's issued by that court, and it is to secure your appearance. It is not to be punitive. And then mitigating and aggravating factors is something that we believe the court should be considering when setting that bond and determining probable cause. And that's why we believe appointment of counsel should be done prior to that, and they be able to understand what's happening in that case, because someone could get arrested wrongfully. Conditions of release, that's usually when the judge decides that you need to be on an anchor monitor, or you need drug rehab, or some sort of protection from possessing firearms. And so these are all conditions of release that can be added if you make bond or if you get an ROR. And then we collect the total amount of the bond. Any questions for that right now? All right, so we're going to look at now will be what a docket looks like when you go into court. We get access to these dockets so that it helps us determine who's before the court. And so these dockets basically have the duty judge, which is Jordan in this case, the date, right? And then it has this one, which is 1 through 20. All right. And so these are the amount of cases you will see on that one day. On this one day, you will go through 20 cases. You will have the name, the race, and the gender, and the birthday of the person that's before you. All right. The charges are in this middle section. You have Medicaid fraud, 3 counts, cruelty to the infirmed. Charisma Scott has aggravated assault, simple criminal damage to property for their charges. And then if you look to the far side, that's where the bond is usually set, and that's where I usually write. Underneath here is where I add the conditions of release underneath the charges. Okay. Again, the court is very adamant about giving you these conditions for release, but this is what we will pick up from the clerk's office. Remember, we do watch monitor the clerk. They give you this sheet, and you bring the sheet into court, and this sheet will allow you to keep track of who is before the court. And I write on this sheet when I'm in court to determine and to collect the data that we use on our observation sheet. Our observation sheet, let's see, where is it? Here we go. Our observation sheet is what what we use to collect data. All right. So this is our observation sheet that we use in actual court. All right. It's broken up into segments. We have glossary of terms. We have general information. We have complete court session if closed. We have complete court session if open. All right. So our glossary of terms, these are things that you will hear in court. Okay. Things you will hear in court is assistant district attorney. That is the person who's prosecuting the case. That is the person whose obligation is to prove whether or not you are guilty of these charges that are before the court. EBRSO is the East Baton Rouge Sheriff's Office. They are in charge of protecting everyone in that court, including those who have been arrested. OPDBR, or the Office of Public Defenders, Baton Rouge. Their job is to defend those that they are appointed to by the court or the reasonable person. AM on the sheet means before noon. EG is, for example, SSI is supplemental security income. That's what I was trying to say earlier. That is what you're given by the government when you are on disability. It's a supplemental security income. It is way lower than it should be. And those who are on that SSI are deemed indigent and therefore should be appointed counsel by the court. The judge is considered the court. There's a 2-hour hour digit. The state is assistant district attorney or the prosecution. Again, that can be 2 terms of art. One is the state, one is the DA, one is an ADA. These are all things that you will hear in court. Those are considered the prosecution side of the court. And their job is to protect the state, right? To enforce the laws of the state. Whereas the defense lawyer is to protect the defendant. There's a 2-digit day and there's a 2-digit month and then a 2-digit year. All right, the general information, and this is A1 through A5, that basically says, who are you? Who's court watching in this court? And so the first name would go there and then the date that you're actual court watching, observation time, what time will it be you've entered court, what time did you leave court, and then what time did court start? So if I entered court at 12:45, that's what time I would put in A4. If court started at 1:01, that's what time I would put there. If I left before, or if I walk into court and court has already started, I would circle court has started before I arrived. And then you already have the time you entered court at the top. And then if court was closed, you would put that there. And then if court was closed, you'd go to the next section, A6 through A8. And then how long did you wait to observe court before you gave up? And then explain what happened. And then what courtroom did you observe? All right. And so if that was it, that was it. And so if you ended up observing court and it was open, hold on. If it was open, you'd go to A6, right? A6 would be how long did you, no, sorry, A9, right? If court was open, you go to A9, and then it was whose courtroom did you observe? You would either do one of those 8 by circling that. And then A10, did you have a call out sheet when you made this observation? This is an obligation that you have to get. You have to go to the clerk's office, and we'll talk about that in our training, where the clerk's office is, how do I get it, and who to ask. But this is your obligation. You have to go, because this helps you. Go to the clerk's office, get that data sheet or that docket, and you circle yes. A11 and A12, did the court explain or apologize if there was a delay? And if they did apologize, then what did they say? If no, you just circle no and you go on to the next one. And did you observe through the end of court session? That's if court is all the way over and everything's over with. Did you observe the end of court, yes or no? All right. On this side, on the page to the left, we talk about defendants, right? We want to know who's been held in contempt. B1 to B6, did the court hold a defendant in contempt for anything other than failure to appear? B2, failure to appear means that they didn't show up, okay? And then B2, if yes to B1, record a name and why the court held them in contempt. All right, B3, did the court hold a defense counsel or prosecutor in contempt? Yes or no? B4, if yes to B3, explain what happened. And then B5, did the court hold a member of the public in contempt? Meaning that someone sitting next to you. There has been instances where there has been a defendant sitting in the courtroom, and they were required to come back to court because they made bond and they wanted to make sure that the judge knew that they had an ankle monitor. And sometimes they sit there the whole entire time and no one ever calls them. And so that happened when I was there the last time. And he finally asked if anybody in the audience had any issues with the court or any things that needed to do to court. And the guy stood up and went over there and talked to the judge, found out that he bonded out and went to the ankle monitoring company and got the ankle monitor and was then free to leave and go on. So that could have been an issue where had this person not shown up or showed up late after court and came in there, he could have been arrested because he wasn't there when court started. So B7, were there ever a time where the perceived defendant was not understanding the proceeding or did not have an interpreter? This is going to be a yes or no question. And then how many defendants were provided court-appointed attorneys? Interpreters. I was saying the same thing last night. How many defendants were provided a court-appointed interpreter? That basically means that their rights are being protected by the state because now they will understand what is happening before them, because that language barrier is huge. And oftentimes the defense lawyer cannot explain to their client what's happening because they don't speak the language. And so therefore, a court interpreter is integral in understanding and expediting the process of that court proceeding. Defendants and victims. Did you observe a defendant who could also potentially be a victim? There are cases where a person is in an altercation with someone and is actually defending themselves, but because they may have won that battle, meaning that the other person went to the hospital, they got arrested. There are instances that you can see that a person has had 2 black eyes or a broken arm, and hopefully that the court will wonder why they're in a cast or in a wheelchair, and ask what could happen. And that could potentially be an issue where this person could also be a victim. Jesse and I have seen this at length in Orleans Parish, where a lady who was beaten by her husband ended up getting a skillet to defend herself, and he ended up going to the hospital in the end, and she was arrested for domestic abuse violence, which was a felony. But because she had a good public defender, that public defender raised that issue that, her arm was broken, her left arm was broken, and she defended herself with a skillet, and that's why she was arrested. Before she got arrested, she had to go to the hospital as well. And so that helped with her bond, lowering of her bond and have her released. And in addition to that, she didn't have any a police record or record. So if you find anybody who could potentially be a victim, put their name and explanation why you think this person could be a victim. And then defendant's identity. Record the names of the call-out sheet from the defendant that requested through counsel and by themselves, referred to by another name, another gender, or another ethnicity. We have seen this in Orleans Parish where someone identifies as a female, but they look like a male. They even have their name changed, and we want the court to respect their identity that they prefer, or want to see if the court respects it or not. It's collecting data. So there have been issues where the court did not respect it. Went too far. All right. In the section of B, reproductive health, you know that abortion is illegal in Orleans Parish. We want to track that to see if anyone gets arrested in Orleans Parish. In the state of Louisiana, we want to track anything that could potentially be deemed an abortion case, miscarriage, stillbirth, abortion-inducing drug, chemical-induced abortion, criminal abortion, RU-486. Any of these that you see up there can be used as an arrest for someone who is trying to get reproductive health care. And so if anybody's arrested for any of those charges, we would circle yes, we would write the names and determine if they are the provider or the patient. Because right now the law is that the person who provides an abortion, provides a pill, they can get arrested as well. And they don't have to be just a patient. And so B13 is that to try to collect that data to see if this is actually happening. And then B14, how many defendants were held until another date for a 313 hearing or a Gwenslar hearing? You want to keep track of that. You want to know names that could potentially be an issue. And then if you heard any defendant had been past their 701 date, please list their names. Right. Again, 701 basically means that the DA has not filed a bill of information in their case to proceed to move that case along to the trial side. Remember, there's a speedy trial issue here. The people don't just get arrested and sit in jail forever. The state has to move that case along to make it to abide by the speedy trial laws. All right. Section C, call out first appearance. So in C through in the C section itself, this is the data that we're collecting mostly from the data sheet. Well, at least the first page is from the data sheet. Name, charges, ethnicity, gender. We talked about that. That's all on that docket that we showed you. And then whether they were present or not is something that you would get from the court itself. All right. There may be an issue where that person appeared via Zoom. Okay. But that's still considered being present. All right. Any income information that we derive from that court session, whether they're employed or receives SSI or part-time or full-time, all this data can be collected to benefit to see how that bond is set. Just take it for example, this person is a full-time job and is a CEO of a corporation and gets arrested for a violent felony, but gets a low bond because he did not deemed a threat. Well, we want to know if this judge tends to do that on people who have means versus people who do not have means. If we don't have that data on that, we wouldn't be able to tell. And so that's when we collect that data. C7, housing. What is the defendant's housing situation? Are they homeless? Are they a stable place to live? This may be mentioned, this may not be mentioned. If it's not mentioned, you say, I'm not sure, or no housing information was presented. All right, and this page 4, gotta make it smaller. What did I just do? Okay, page 4, we have who defended this person? Was it a private attorney? Was it an OPR, OPDBR, or were they unrepresented or were they self-represented? This data is extremely important, especially if they're self-represented, because that is, even though it's part of the law, you can represent yourself, but your rights should be protected. Then we have risk questions. If the defendant was charged with domestic abuse, what the court mentioned or the victim's response to any of the following questions, which could, if these questions were asked, do you think he or she will seriously injure or kill you? This is the police, this is BRPD asking the victim if they were asked these questions. How frequently does he or she intimidate, threaten, or assault you? Describe the time you were most frightened and injured by him or her, and then describe the time that you were most, and then have you ever been threatened or intimidated by a defendant for seeking help or attempting to seek help from law enforcement or the courts itself? There's a gun risk if there's a stay away order in place. Having a weapon is a no-no, and that's protection of the victim and the community. And that is, see if that question is asked, do you own a firearm? And then no probable cause. If no probable cause is determined on all or was the release of the defendant. So did the court find there was no probable cause on all the charges in order to release the defendant? If yes, write the court's stated reason. All right, they usually will give a reason for that. And then C12, these are the reasons for setting bond. Did the court give, or the reasonable person give, their reasons for setting that bond that high or that low? Seriousness of the alleged crime, the weight of the evidence against the defendant's ability to give bond, income or employment, defendant's pretrial risk score, which I probably don't have in Orleans, in Baton Rouge. Pretrial services report, again, they probably don't have that in Baton Rouge. Defendant's previous criminal record and whether the defendant is currently out on bail and have a previous felony arrest, felony voluntary participation in a pretrial drug testing program, positive or negative drug test results, and no, the court did not say any of the following factors applied to the defendant's case. Or I'm not sure. And then bond, C13. Did the court sign out or release on an own recognizance bond? I have seen a sign out bond and I have seen release on own cognizance. So the state does do these releases. And then if you're not sure, you're just not sure. and the defendant ordered to remain in jail without bond, explain why. And then how much was the bond, right? Write the dollar amount for the bond. Usually it's, even if you have 4 charges, you write all of them down because the entire amount added together is what they have to pay to bond out. It's not one or the other, it's all of them. And then conditions, C16, what financial conditions did the court order on the bond? Was there a protective order, stay away order, prohibition against possessing a firearm, domestic violence counseling or mentoring, GPS ankle monitoring or electronic monitoring or tracking, drug, substance abuse, or mental health treatment, drug testing, curfew, interlocking device, or forbidden to leave jurisdiction. And then comments in C17 about your first appearance and including any other commentary the court made when making these determinations. Now, this next page over to the right, this is where you can write the name, the charges, the ethnicity, gender, and whether or not they were present in those first 3 columns prior to going to court. And then the other columns can be filled in as you hear them in court. Whether they have income, whether there are any housing issues, who defended them, public defender or a private attorney, any risk questions were asked, is there a gun risk, did the court find no probable cause, and what are the factors the court used when setting that bond, what's the bond and what's the amount, meaning the bond could be a cash bond, a surety bond, an ROR, or a sign-out bond, right? And then the amount of the cash or the surety bond. And then did the court ask, could they afford? And then any conditions that was added by the court in C16, and then comments on the other side. And then there's another page for you to get if you have too many people on this other page for the back and front. And then you have D1 through D4. This is just your general impressions of that court hearing. And we're going to talk about on a scale of 1 to 5, rate that party's overall demeanor to everyone in court, meaning the ADA, OPDBR, private defense counsel, the court, and EBRSO. Now, 1 is the lowest part. It's the lowest side of this. It's disrespectful, unprofessional, unrepresented. Unprepared, tardy. Those are all on the low side. On the 5 side, respectful, professional, prepared, punctual. Okay. And if the party in D1 received a rating of 1, please list why. So if any party is bad, is listing is as a 1 or a 2, give us a reason why. And then D3, please check all of that apply that perceived or observed that anyone was treated improperly or differently for any other reason and explain in the space provided what happened. So if someone is you felt was discriminated against because of their gender, because of their race or ethnicity, their religion, their age, disability status, sexual orientation, economic status, or language, you can check that off and then write what you felt about that and why did that make you feel that way. And then D4, write about your day in court, including any compliments, any criticisms, any suggestions, any recommendations or concerns that you may have in D4. Any questions for me on any of this that we just went over? Jesse? Yeah, go ahead.
I think Jesse had mentioned that the judge may want to hold a conversation with us. Now, does that mean that, once we report to the bond office and get the call-out sheet, that means that he knows that we're in there? He knows that do we identify ourselves? How does he know that we're doing this?
You won't know you're in there until you walk in. And the thing about it is we give you a bright yellow clipboard and you have a lanyard around your neck that they can see automatically as being from Court Watch. And so that sets you out apart. We want them to know that they're being watched. And so he'll know. And he can say, hey, how you doing, Court Watch? I hope you're well, blah, 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 blah. Let me know if you need anything. Other than that, it's just hopefully simple chat.
They're very familiar with Court Watch, with court watching. There is another court watching organization that we are closely tied to. Reverend Anderson has been court watching in there for several years. She's in there every day. So you won't be the only court watcher in the room. There's sometimes, you know, 2 or 3 or 4. So they are very well acquainted with having folks in there, and we will just be, you know, adding to the roster.
Now with
And
the
we have a
call
question
out,
in the
with the
chat
call
as
out
well.
sheet, do we upload it? Once we fill it out, we scan it and we upload it.
So you're actually going to have you'll have a link to an upload form, and it will be tied to the questions that are on the observation sheet. So like question A1 will be A1 in the upload form. So you won't need to scan or upload the call out sheet. That is strictly yours to, you know, use to take notes and do whatever you want with it. So the printed observation sheet and the call out sheet, you know, like you do whatever you want with them. You will never turn them back into the court or never turn them back into us. You'll have a link to an online form that you go to that you transfer all the information from that observation form into the upload form, and that goes into our statistical database, and that's where we house all the data.
Okay.
But good question.
Sheila, Gwen's law is Gwen's law is also 313. 313 is a hearing, it's a statutory hearing that is required, that can be required by if the court requested for more information in that case. That just means that if this information is requested, this person will not get a bond, and that bond will be strictly related to that hearing. It could go one way or the other. It can go where that bond gets so high that this person cannot get out because of the evidence that they derive from this hearing. And it can be that this person is released on no bond, not saying no bond, because there has to be a bond on this case, on a violent case. It could be a low bond because of the evidence derived from that hearing as well. And so Gwen's law hearing is a protection that's instituted by the law to protect the victim of a domestic violence incident. I hope I answered your question, Sheila. Any other questions?
I think you covered this already, but I think I missed it. This whole procedure, is this a volunteer basis, or there's compensation, or is this like a job that we enter into?
Yeah, it's a good question. It's a volunteer program. You know, I think in the long run, we would love to get funding where we can, you know, pay people to do observations, because we know that it is a significant investment in time and energy. But as of right now, we don't have that funding, so all of it is volunteer. You know, what that means is that you know, we understand that like you are volunteering your time. And so like when we assign you to do things, that's why we're, you know, working around your availability and your schedule, right? You tell me like this is how often I want to do it. These are the days that I'm available to do it. And I'm like, great, I will take what you have to offer. And that's how I do the assignments, because we're understanding that, you know, you are going, you know, above and beyond your calling to contribute something of great value to the community, and so we're appreciative of that.
And they don't have any after five court cases, do they?
Right now, we're only doing call out, which is at 1 p.m. Like I said, it's usually like 1 to around 3. I don't think they have any proceedings that happen after 5 p.m. So I think that when we expand into other courts, it would be expanding into earlier in the day. But I'm not aware of any in the evening. Yeah, and then Sheila on oh, okay, I see what your question was. Yeah, so you don't, just in general, you don't necessarily have to take a fresh observation sheet every time you go to observe. you'll eventually reach a point where, you come up with your own way of recording things, that you don't need to fill out that sheet every single time. And I've seen Darrin, I know he's the same way. We take all of our notes directly onto the call out sheet, because we've been doing this for so long, like we know what all the questions are. So it will probably take you a little bit to work up to that, but you will eventually get there, and you won't need to print a new sheet every single time. And that's especially important because, again, those are tools that are just for you to capture the data. What really matters is when you input it into the online form, that's where things really matter. So, if you don't need to print a new sheet every time, and you take all of your notes like on a legal pad or directly onto the call out sheet, if that's what works for you, that's what works for you. Okay, so we're doing good on time. I just have a couple more things for you. I sent an email out about the in-court training. We have one scheduled for next Tuesday at 1 p.m. That is the second half of this training program. We will actually go to the 19th JDC. We will see a call-out session. We'll go to the bond office so we can get the call-out sheet. And then we'll go in and we'll actually sit down and observe so you can see what it's like. And then after that, we'll be ready to start putting some folks on the schedule, and actually do some live observations. That is the only one we have scheduled right now. We are looking at adding more. So if you're unable to make it to that, don't fret. But that is the one that we could schedule currently. The sign up link is in that email. So if you go sign up to that, I'll send you all the details about, where we're meeting, what time we're meeting, where you could park, all of that fun stuff. So last thing I have for you is a bit of a pep talk. I think it's my most important job here at Court Watch. I think it's really important to acknowledge that what we're asking you to do is incredibly difficult, and you are almost certainly going to struggle at it. I am the sort of person that when things don't come immediately easy to me, I get very frustrated, and sometimes I am inclined to want to just stop doing those things because, like, I'm a smart person and I do things easily the first time, and it's physically uncomfortable to me when I'm bad at something. And I just want to name that, like, you will probably struggle with some of those feelings the first time you go to do this. We know how tough this is. If this was easy and court was super transparent and everybody could understand it, we wouldn't need to do this. So just by the nature of the thing that we're doing, it is implied that it's going to be hard and it's going to be difficult. So, recognize that, like, you are not the thing that is broken. You are not the thing that is wrong. I can tell you just by showing up, you are making a difference. Like Darrin said, we're going to roll up in there with bright yellow clipboards and lanyards around our neck because we want to be seen. We want people to know that they are being observed. And just by sitting in that courtroom, you change the outcome. Darrin and I have both seen multiple people that, like, they might have failed a drug test and the judge was like, all right, you're going back in. And the person's walking across the courtroom, going to jail. And the judge looked up and saw us sitting there with yellow clipboards and like 7 trainees. And the judge is like, you know what? I've had a change of heart. I'm going to give you one more chance, right? That doesn't go down like that if we're not sitting in that courtroom. We've had multiple people that have come up to us after their hearing and said, the judge was completely different to me when you were here. I don't know what changed, but that was a different person than the person I met last month. And thank you so much for coming. So just by being in the courtroom, you are making a difference. If you didn't capture a single piece of data when you were sitting in there, just by showing up, you did something good. You're gonna sit there and, like, if you have, we saw that call out sheet that had 20 cases on it. The first time you go, you might be totally confused. You might only catch 3 or 4 of those cases. That's okay. That's okay. You might be inclined to say like, oh man, I missed 17 cases. 17 cases I missed. I only caught 3 out of 20, but those are 3 cases that we wouldn't have data on if you weren't sitting in there. If you only catch 3, if you only catch 1 out of 20, that's still 1 that we don't have. And that might make a difference in the long run. And you will get better at it. The more you sit there, the more you do it, the more you get comfortable, that, you know, things start to slow down. Like it's going to feel like it's moving super fast at first, and it's going to slow down for you. It's going to make more sense, and you'll encounter the terms and they won't be confusing anymore. And you just get better at it the more you do it. So I promise you, I know that if you can work through that uncomfortable feeling of feeling like you're just doing a bad job, and you give it enough time, you will get it down, you will get better at it, and you will be like a really good court watcher. So like I said, I think that's my most important part of this job, is just reminding people that, because it's hard. It's really tough. It's really tough, but you're going to do great at it. And like I said, even by showing up, like, you've done something awesome. That is all we have for you. We're going to give you a little bit of time back. Like I said, check your email. That's got the information for the in-court training. And thank you so much for coming today. And we are really excited to get y'all in the courtroom.